sentencing. When an accused pleads guilty or the court finds the accused guilty at the end of the trial, the court must provide sentence that is consistent with the law. After that, before the sentence is passed, the defense counsel will usually make a plea of mitigation, which is an art of moving the court to grant a lenient sentence. On the other side, the prosecution will submit aggravating factors and press for a heavy sentence.
Aim of sentencing. The main aim of sentencing recognized by the Malaysian courts are, for instance, retribution, deterrence, rehabilitation, prevention, and protection of society. Retribution is the retributive sentence is very heavy, which may be death or life imprisonment. Deterrence is the sentencing aims to deter further offending by punishment and making the consequences of criminal behavior clear to individuals and society. Rehabilitation is a rehabilitative sentence, is a lenient sentence to offer the accused an opportunity of starting new and is imposed usually for the first offenders or trivial offense.
Okay, hi, I'm Jesselen from Best 19 and I'm doing Diploma in Enforcement Management. So I'm here to explain about sentencing principles. Okay, first of all, if the court finds the accused guilty of an offense or if a plea of guilty has been recorded and accepted, the court shall pass sentence according to the law. Furthermore, the court must pass sentence within its sentencing jurisdiction. Moreover, in PP v. Jafar bin Daud in 1981, 1 MLJ 315, Muhammad Azmi J said that the phrase pass sentence according to the law means that sentence is passed according to the punishable section and is to be assessed with established judicial principles. Okay, thank you.
Hi, my name is Vigneshwar Kitanabalan. I'm going to present about type of sentencing. That under section 121 of the Penal Code for the offence of waging war against the YDPA or a ruler of Yang di-Pertuan Negeri. Section 302 of the Penal Code for the offence of murder. Section 364 of the Penal Code for the offence of kidnapping or abducting in order to murder. Pregnant woman under section 275 of the CPC substitute the death sentence with 1 life imprisonment. Child or young person under section 97 of the Child Act 2001 provides that a death sentence will not be pronounced or recorded against a child convicted of an offence. The court should order the child to be detained in a prison at the pleasure of the YDPA or the ruler and or the YDPM.
Very good morning, my name is Pritham Longan. Today I would like to present about the continuous part of type of sentencing. Imprisonment for life. Section 3 of the Criminal Justice Act 1953 defines imprisonment for life to mean imprisonment for 30 years with a remission of 1/3 for good behavior. On the other hand, for offences under the Firearm Increased Penalties Act 1971, the Arms Act 1960, Section 130 of the Penal Code, imprisonment for life means imprisonment for the natural life. In She Any B item, fees, Public Prosecutor 1984 1 MLJ 113. The issue was whether the life sentence for the duration of the natural life under Section 4 of the Firearms Increased Penalty Act 1971 was unconstitutional and violates Article 5.1 and Article 8.1 of the Federal Constitution. The Federal Court referred to PPB Lau Q Hu in 1983 MLJ 157 and held that. Second is imprisonment for a fixed period. Section 282 D of the CPC provides that every sentence of imprisonment shall take effect from the date on which the sentence was passed unless the court otherwise directs. Besides, Section 102 of the Superannuated Codes Act 1942 provides that if a magistrate court has to impose more than one sentence of imprisonment at one trial, the court may order the sentences to run concurrently to consecutively, provided that the maximum does not exceed 20 years. Notwithstanding, other courts are not restricted to this imposition of a maximum sentence of 20 years. Second is imprisonment for a fixed period. Section 282D of the CPC provides that every sentence of imprisonment shall take effect from the date on which the sentence was passed unless the court otherwise directs. Besides, Section 102 of the Superannuated Codes Act 1942 provides that if a magistrate court has to impose more than one sentence of imprisonment at one trial, the court may order the sentences to run concurrently to consecutively, provided that the maximum does not exceed 20 years. Notwithstanding, other courts are not restricted to this imposition of a maximum sentence of 20 years. In Abu Salman v. Public Prosecutor 1982 to MLJ 338, the accused was convicted on 3 counts of giving RM5 to each voter to induce them to vote under the Election Offences Act 1954. The magistrate sentenced him to 5 days imprisonment and a fine of RM100 for each offence, and the imprisonment was not run consecutively. On appeal, it was held that if several offences were committed in the same transaction, the sentences are to run concurrently as in the case. The order was altered to a concurrent sentence. In Anandan Subramaniam is Public Prosecutor 2007, HCLG 1, the appellant pleaded guilty for the offence of rape under Section 376 of the Penal Code and for voluntarily causing grievous hurt to the same victim under Section 326 of the Penal Code. On appeal, the court held there was continuity of sections since both offences were clearly connected by proximity of time and place. Thus, the sentences should run concurrently.
Hello, my name is Nuri. My part will be the conclusion of sentencing. People are in general law abiding, but it is also true that everyone breaks the law sometimes, and some people break it often. Compliance with the law is never complete. Lawbreakers have to be dealt with in accordance with the law. Thus, in any society, there is some form of system in place to tackle this problem. In Malaysia, the justice system has been in place even before independence in each of the individual states, and when Malaysia was formed, the justice system that was adopted seemed to work well in preserving the laws of the country. Based on the study, it finds that there is a disparity between the theory of principle of sentencing and the actual result, as according to the index crime rate in Malaysia. Therefore, a proper and thorough study needs to be carried out to evaluate and determine how efficient our mode of sentencing is in reducing the crime rate, and reform should be proposed to the current system of sentencing. In order to bridge the gap between theory and reality, Malaysia have to initiate further research in reforming the present sentencing system in order to reduce the crime rate for a safer Malaysia. That's all from me. Thank you.